Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, February 8th, 2023. The time is 9:30 a.m. With us today are Commissioners Emily Lindley, Bobby Janecka, as well as our General Counsel, Mary Smith, and I'm John Neerman. It seems that our sound system has taken a beating similar to the urban forest here in Austin, and so we are on a backup system and appreciate y'all bearing with us. For those of you who are joining us virtually, I'd like to remind you to please keep your microphones muted when you're not speaking. For those making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. The registration is now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to speak to, and we will do our best to accommodate that request. With that, I'd like to thank everyone for being present, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by the City of Liberty Hill for renewal of Texas Pollutant Discharge Elimination System permit number WQ00144777001. The order of presentation will begin with the applicant, followed by protestants, the ED, and then OPIC in that order. The parties will each have 5 minutes of oral argument time. The applicant may reserve time for rebuttal as it bears the burden of proof on the application. With that, we'll ask for Ms. Natasha Martin for the applicant.
Good morning. Is there a button I've got to push here?
Ms. Martin, I think I'm just going to speak into
that's perfect.
to the microphone
Okay.
on the stand.
All right, let's not count that.
Yeah.
5 minutes.
Good morning.
All right. Good morning, Chairman Newman, Commissioners. My name is Natasha Martin of Graves Doherty here in Moody. I'm here on behalf of the City of Liberty Hill. I'm joined with our plant operator, David Thomason, compliance officer, Vince Perkins, and our engineer, Aaron Laughlin. As you know, Liberty Hill is a regional wastewater provider in Williamson County. The city's asking to do 2 things today: simply renew its permit and obtain a minor amendment to adjust the interim phasing in the permit. This request does not increase the final limit that's already been approved by the Commission. You'll see that the record shows that the compliance issues related to nutrients or water quality that led the Commission to send this renewal to a contested case hearing are outdated to some respect and also have been resolved. Any recent NOVs, the record will also show, have been related to flow, and also there was one related to maintenance. But as far as flow goes, there's been a struggle with keeping our flow down because of demand while this application has been pending. The city's taken drastic measures for compliance even before this matter was referred to SOA. Those include putting in a brand new NPR plant. Record shows that the city hired a AA class wastewater operator. He's rated A for water and wastewater operations. And the city voluntarily operated its effluent discharge at 0.15, which is the limit in the draft permit, not the limit in the 2015 permit, which is 0.5 total phosphorus. So the record shows that the city has proactively addressed compliance concerns. We do have exceptions. I had PowerPoint, but we had some technical issues. I won't cover all of the exceptions, but I will maintain the exceptions that we previously filed. Here, I'll cover everything really related to total phosphorus. This limit of 0.05 would immediately put the city into non-compliance. Further, it's the city's position that the ALJs did not follow the TCEQ's established rules in setting the limit at 0.05. First, 0.05 is not a reasonably achievable technology limit. We'll talk about that. Second, 0.05 is not proven to maintain high quality conditions as the PFD finds. Third, no one has rebutted the prima facie case that 0.15 is protected using the Commission's rules. So as far as 0.05 not being RAT, the ALJs failed to consider the IP's standard for reasonable. The record shows that the technology relied on is not reasonable for several reasons. The PFD largely relied on a pilot test of the Clearest technology at the Liberty Hill plant. The record shows that pilot test results would immediately cause the city to go into non-compliance for ammonia and nitrogen permit limits. Second, the record also shows that Liberty Hill's influent, its received sewage, that ammonia content was too high. And so for Clearest to properly work, our engineer testified that we would have to add chemicals and add pollutants to the system in order for Clearest to achieve the reductions necessary. Our engineer, Mr. Laughlin, testified that for these reasons, that 0.05 is not a reasonably achievable limit. It couldn't be, we don't expect that the IPs intend for that situation to be considered reasonable. Second, protestants seek a lower TP standard based on background conditions, although nowhere in the TCEQ rules is there a standard for applying background as the basis for establishing an effluent limit. The record shows that 0.05 does not guarantee what the ALJs anticipate. The city's biologist, Dave Buzan, has over 40 years of experience, 9 of those as manager of the state's surface water quality monitoring program. He said there's no target number, and that is consistent with the fact that TCEQ has no numerical standard for TP. It has a nutrient standard. So Dave Buzan, we think, hit the nail on the head. The ALJs are not relying on the established narrative standard when setting this 0.05 limit. The best course of action, if the TCEQ were in the future want to consider setting a nutrient standard, would be using the IPs, setting it at 0.15 now, and then monitoring effluent concentrations from this plant in comparison with the conditions of the river. The draft permit already includes nutrient, it already includes monitoring, but the PFD includes a nutrient study requirement. We've already done a nutrient study, so that study will help facilitate setting a standard later, but that's not what applies now. That's not the law now. Third,
That's 5 minutes.
that's my 5 minutes. Yeah, please wrap up. Okay.
Just offer a concluding thought, please, Ms. Martin.
My concluding thought, I love this one. Setting a standard at 0.05 for a plant that was designed for 0.15 is immediately putting you into non-compliance. It is putting a minivan into the Indy 500. You're setting this system up to failure. And we've done so much good work to achieve compliance in the last year and a half. All right, thank you.
Thank you, Ms. Martin. Colleagues, any questions for Ms. Martin?
Thank you. I only have one question, Ms. Martin. I wonder if you could speak to the nutrient study portion that I think the ALJ referred to in the record of a following period of time to monitor. Is there any component of that that's still being undertaken?
So the city was required to do a nutrient study as part of an enforcement action. And because the parameters of the study required certain rain flow conditions, we were in the midst of doing that study during the contested case. We had a massive drought last summer. We couldn't get it done. It was finally finished in November, and the ALJs, they didn't enter the study in the record, but they did say that we would consider that study as like the first year of compliance. So we would, every 2 years, we would have to do the study. This one would satisfy that first 2-year requirement. I don't know if that answered your question.
Okay. I'm hearing the city understands they have an obligation to repeat this activity or continue studying these parameters and factors. But that answers part of the question. Thank you.
Sure. It's a pain. Ms. Martin, thank you. Appreciate it. We'll hear next from the protestants. Is it Ms. Hone?
Yes, it's me.
Good morning.
Good morning. Should I go ahead and get started? I know we had some pictures that we wanted to show.
If you need to, just a moment to set up, we won't count that against your time. And when you're ready, just go ahead and introduce yourself.
Thank you, I appreciate it. We were a little nervous about technology after all the ice.
You were right. You were right to be nervous about it.
Thought we'd go old school. All right, I'm ready. So, as you've already said, I'm Lorraine Hone, and I'm here on behalf of Stephanie Ryder Morris, who's right there. With me also is my co-counsel, Lauren Ice. There's also another group known as the Bunnell Protestants, who have very graciously agreed to allow us to use the entire 5 minutes allotted to the Protestants. So the City of Liberty Hill, or its predecessor, has been discharging into the South Fork San Gabriel River since 2006. This river is extraordinarily sensitive to nutrient input. It's low flow, it's low in background nutrients like nitrogen and phosphorus, and that means that when it is exposed to a large quantity of nutrients, such as from a wastewater discharge, there is inevitably going to be a massive algal bloom. And that is what is happening here. As you can see here in this photo, taken by Ms. Morris on May 26, 2022, the river upstream of the outfall is clear and largely devoid of aquatic vegetation. This is the river's natural state. It is reflective of baseline conditions. Whereas this photo, taken on the exact same day, shows how the algae problem starts right at the outfall. The evidence in this case shows that if a wastewater discharge is to continue into this section of the river, nutrients have to be severely limited. The burden of proof was on the city to demonstrate that the draft permit met all legal and technical requirements. That includes that the discharge will not cause or contribute to a violation of water quality standards. The city has utterly failed to meet this burden, and the city and commission staff provided no substantive evidence that the draft permit will be protective of this river. On the other hand, we have 15 years worth of evidence, both qualitative and quantitative, that demonstrates that the discharge will cause the growth of algae and the violation of water quality standards. This includes detailed eyewitness testimony from and countless photos and videos taken by landowners who have lived along the river for years. And it includes the Commission's own documented concerns and observations concerning the river's condition. Critically, there is also ample evidence that under the draft permit, this excessive algae growth will continue. This includes testimony by Drs. King and Ross that was based on their personal observations of the river, their knowledge of the relevant scientific studies and experiments, and Dr. King's water sampling for this case. The observable conditions in the river can be scientifically compared to the background levels of phosphorus in the stream, which are at or below 0.01 milligrams a liter naturally. The data shows that if concentrations of phosphorus approach 0.02 milligrams a liter, algae will bloom. This photo down here, taken by Dr. King on April 4th, 2022, shows what the river looks like after more than 4 months of discharge, averaging around 0.07 milligrams a liter, about half the current proposed phosphorus level of 0.15. And obviously we know that the algae doesn't disappear from the river overnight, right? But right after that, the city cleaned a huge section of the river and the algae started growing back immediately, fastest near the outfall. And this photo on the bottom left shows what the river from Ms. Morris's property looked like on June 3rd, 2022. These are but a small sampling of the photos that are on the record in this case. And according to the experts, this is what the river will continue to look like under the draft permit, specifically the ones downstream of the algae, of course. No evidence has been offered by any party to rebut this. The only contradictory opinions are conclusory statements that the draft permit will protect water quality. The record shows that 0.02 milligrams a liter total phosphorus is protective of water quality and reasonably achievable as a permit limit. The ALJs agreed that 0.02 milligrams a liter is protective of water quality, but they believe that 0.05 milligrams a liter is what is reasonably achievable. It is up to the Commission today to decide which of those two numbers to put into the permit. We recognize that reaching such a phosphorus limit, while reasonably achievable, is not possible overnight. But there are plenty of ways to protect the river in the short term through a compliance plan, such as capping total phosphorus temporarily, reducing discharge into the river via temporary pump and haul requirement, and continuing to remove algae from the river. If the permit is issued here today, the ALJ's recommended changes are the absolute minimum that must be done to protect the water quality in this river. Nothing less stringent is supported by the record. And I would like to make it clear that Ms. Morris does object to the city's exceptions and the reply to exceptions, as both were filed late, and also objects to the nutrient study that was attached to the city's exceptions, as that is not on the record in this case, and so would be impermissibly before the commission at this point. Thank you.
Thank you, Ms. Hood. Colleagues, any questions for Ms. Hood? All right, let's hear next from the executive director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Bobby Salehi from the Environmental Law Division. With me today are Feroz Vahora and Peter Schaefer from the Water Quality Division. Executive Director staff reviewed the City of Liberty Hills application for renewal with minor amendment of TPDES permit number WQ001-4477001 and drafted a permit based on that application that will protect human health and the environment. Regarding the 10 issues the Commission referred to SOA, the Executive Director supports the ALJ's conclusions on issues B, C, and F. The Executive Director respectfully disagrees with the ALJ's conclusions regarding the remaining issues. As written, the draft permit is in compliance with all applicable statutory and regulatory requirements. The Executive Director recommends that the Commission reject the proposals of the ALJ and their proposal for decision and issue the permit as drafted by ED staff. Thank you, and we are available for any questions.
Thank you, Mr. Salehi. Colleagues, any questions? Let's hear from the Office of Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Pranjal Mehta for the Office of Public Interest Counsel. OPIC supports the administrative law judge's proposal for decision and the recommended revisions discussed by the ALJs in their letter considering the parties' exceptions to the PFD. OPIC maintains the positions taken in our closing brief that the city has not met its burden of proof on the issues regarding water quality standards, nuisance conditions, wildlife and health protection, city's compliance history, and facility management and monitoring. Regarding the issue of water quality, based on the weight of evidence in the record, OPIC cannot find that the draft permit is protective of water quality and uses of the receiving waters in accordance with the Texas Surface Water Quality Standards. As explained in the PFD, there is overwhelming evidence in the record which demonstrates that there is an excessive amount of algae in the South Fork San Gabriel River at and below the city's outfall, and the cause is the city's discharge. However, if the draft permit is changed in the ways recommended in the PFD, OPIC would be satisfied that the draft permit would be protective of water quality, existing and designated uses of the receiving waters, and related concerns. OPIC agrees with the ALJs that the preponderant evidence established that a reduction of effluent total phosphorus is needed, and 0.05 milligrams per liter is a reasonably achievable technology-based limit. OPIC also agrees that the draft permit should be amended to require the plant be operated by a Class A license holder. Such a requirement, especially considering the city's past compliance history, would ensure that the operators with the highest license qualification would run and monitor the city's facility, which would result in more reliable operations in the future to preserve water quality. Given that the plant is currently operating and serving the residents of Liberty Hill, OPIC recognizes that outright denial of the city's renewal application may not serve the public interest. Therefore, in lieu of denial, OPIC recommends amendment of the draft permit with the 4 modifications recommended by the ALJs. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Mehta. I have none. Colleagues, any questions? Okay. Here's my analysis. Let me begin with issue A. That is whether the draft permit is protective of water quality, groundwater, and the uses of the receiving waters in accordance with the Texas Surface Water Quality Standards. I agree with the ALJs that the protestants presented sufficient evidence to rebut the prima facie demonstration that the proposed total phosphorus limit of 0.15 milligrams per liter is protective. However, while the city and the executive director did not adequately support the limit, nor, in my view, did the protestants or the ALJ's findings appropriately establish what level of total phosphorus is required to satisfy the standards. The legal standard for implementing the narrative criteria of Texas Surface Water Quality Standards is to maintain the existing uses of the receiving waters and to prevent degradation of water quality by more than a de minimis amount. But rather than address what is necessary to maintain uses and prevent degradations, the ALJs, it seems to me, have recommended a total phosphorus limit based on testimony about what is achievable with existing technology. And that, colleagues, in my view, is a misreading or at least an overreading of the implementing procedures. The limit is not predominantly a question of the capability of reasonably available technology. Rather, the analysis must begin with what is protective of the waters under the Texas Surface Water Quality Standards. And colleagues, I cannot find sufficient evidence in the record to determine what the protective limit would be. That is, what the specific total phosphorus limit should be in the permit. So I'm going to suggest that we remand this issue to SOA with instructions that the parties present evidence to determine the specific total phosphorus limit that is necessary to comply with the Texas Surface Water Quality Standards. And because issue D turns on the total phosphorus limit, I would remand that issue in conjunction with issue A. As for anti-degradation, that's issue G, I agree with the ALJs that the purpose of the anti-degradation policy has not been satisfied on this application, and that it is not appropriate to rely on the previous anti-degradation review given the city's performance under the existing permit. So I would suggest that this issue can be taken up on remand as well, and the parties will have an opportunity to present additional evidence on the specific total phosphorus limit that will satisfy the anti-degradation policy. Turning to issue B, I do not have a sufficient basis to overrule the ALJ's determination that the draft permit is protective of the requester's health and the health of wildlife. As for nuisance, I agree with the ALJs that the draft permit does comply with 30 TAC section 309.13E. However, because we do not yet know what the appropriate total phosphorus limit is, we can't say that it is adequate to protect the requester's use and enjoyment of their properties. So on issue I, relating to use and enjoyment, that would need to be addressed on remand. Regarding compliance history, the inquiry is broader than compliance classification, and in any event, on this record, it's not been a good compliance history. So the record does support increased monitoring. It does support third-party operator requirements included in the draft permit. As for the need for the facility, I do agree that the applicant has met its burden on that issue. Turning to issue H, and that is whether the executive director may increase a facility's classification with respect to the operator license requirements. The standard is that the ED has that discretion for facilities that, quote, include unusually complex processes or present unusual operation or maintenance conditions. I don't see a demonstration in the record that the membrane bioreactor is a complex treatment process or has unusual operation conditions. So I would not adopt the ALJ's recommendation to require employment of a Class A licensee. That said, I do appreciate that the city has elected to employ a Class A licensee, and I would be happy to see that continue. That takes us to issue J. I agree with the ALJs that turbidity monitoring and signage are not necessary. I also agree that it's important to continue the assessment of nutrient discharge and its effect on algal growth in the receiving waters after the city begins discharging under a renewed permit. And I'm referencing the nutrient sampling plan, the study. As for posting monitoring information on a public website, I think it'd be a good practice in this case, given the history and considerable public interest on this application and permit. I'm glad that the city is open to that idea. I think if that information is not posted, I imagine it could increase TCQ's burden in responding to public information requests. So I would encourage the city to take that on, but on a voluntary basis, because there's no legal requirement. At least at this moment, I would not impose that obligation. And finally, for transcript costs, I think we can take that up after the remand. So colleagues, that covers my analysis. And Commissioner Lindley, I'll invite your thoughts. Okay.
Sorry, thank you. I don't have much to add. I think I'm in total agreement. You know, the only comment I'll make, and it's basically just an echo of what you were saying and some others have said today, is, you know, I do believe a remand is necessary. I don't believe there's sufficient evidence in the record right now to pinpoint what the total phosphorus level should be, or the limit should be in the surface water quality standards. I also believe that an outright denial at this process wouldn't necessarily be in the public's interest. So kind of, it's in a weird spot. With that said, I want to make sure if it gets to the point where we're comfortable issuing a permit, it is protective. I'm not there today, so I agree that a remand on phosphorus is most appropriate.
Thank you, Commissioner.
Thank you. Just a few thoughts to add myself. I feel that a remand to SOA is necessary for this matter to pinpoint the specific total phosphorus effluent limit necessary for the draft permit to comply with the Texas surface water quality standards. I believe the city and the ED failed to support the reasoning for the total phosphorus effluent limit included in the draft permit. And the protestants' suggested limit and the ALJ's proposed limit are not sufficiently based on the criteria in the surface water quality standards. In this case, given the compliance issues and the level of algal growth, I think it would have been helpful for me to have an anti-degradation analysis in the record to better understand what is going on with the receiving water and what is necessary to protect the water quality going forward. For these reasons, I would remand the matter to SOA to take additional evidence on the TPF limit.
Colleagues, it sounds like we're in agreement, and I think we're ready for a motion.
I'll give it a whirl, and if this doesn't, well, anyway, you all weigh in. I move that we remand this matter to SOA for the parties to present additional evidence to determine the total phosphorus effluent limit necessary to comply with the Texas surface water quality standards. Under the standards, the total phosphorus effluent limit should prevent the excessive growth of algae that impairs an existing use of the receiving water and should prevent the degradation of water quality by more than a de minimis amount.
Second.
The motion is made. We have a second by voice vote and show of hands, so I'm not passing the microphone around. All those in favor say aye.
Aye.
Aye. The motion carries unanimously. Thank you all for the presentation this morning. Ms. Smith, when you're ready, I'll ask you to please call the next item.
Item number 2 is the consideration of the application by Pro Lockhart 450 LLC for new TPDS permit number WQ00161070001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
For the benefit of those who are not familiar with our process, we have a two-part process for considering requests for contested case hearings on TPDS applications. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met those requirements, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. And colleagues, on this item, we have 2 requests, and without belaboring it, I agree with the Executive Director and OPIC that both Ms. Garrett and Ms. Walker have met the procedural and substantive requirements to be entitled to a contested case hearing. Turning to the issues, the requests express some concern about property values, which may be a legitimate concern. However, they're outside our jurisdiction on this application. And in fact, most agency actions. The requests also raise several issues that are relevant and material to this application, and they are as follows. First, whether the draft permit protects against nuisance odors in accordance with 30 TAC section 309.13, and whether the draft permit is protective in accordance with the Texas surface water quality standards and other rules of the following interests: surface water quality, existing uses of the receiving waters, groundwater, aquatic life, flora and fauna, and finally, the health of the requesters and their families. And colleagues, I would also include an ADR referral and allow 180 days for this hearing. Commissioner Lindley.
I'm in agreement.
I don't have any comments with agreement.
Thank you. I too am in agreement, and we'll take this opportunity to deliver a motion. I move that we grant the hearing requests of Dana Garrett and Shalana Walker. We refer the matter to the TCQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, and that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of groundwater and surface water quality, including the protection of the requesters and their families' health, existing uses of the receiving waters, aquatic life, flora, and fauna in accordance with applicable regulations, including the Texas surface water quality standards, and B, whether the draft permit adequately protects against nuisance odors in accordance with 30 Texas Administrative Code section 309.13. And I finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Thank you. That one also passes unanimously. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the application by Two Creeks Crossing Resort LLC for new TPDS permit number WQ00160560001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, again, we have a two-part analysis for considering a request for contested cases. Part 1 is about who gets a hearing, and Part 2 is about which issues. And again, requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. There is a single hearing request on this item by Ms. Griffin. However, I agree with the executive director and OPIC that Ms. Griffin's hearing request was not based on concerns that were raised in timely comments. We're therefore required to deny her request. We also have a request for reconsideration on this item by Mr. Mansell. However, it raises no new issues, and the concerns expressed have been addressed in the executive director's response to comments. So I would deny that request as well.
I'm in total agreement once again, and if you're shaking your head,
Let me grab it back, but please make the motion. All good.
I will make a motion then. Essence out of the microphone. I would move that we deny all hearing requests and request for reconsideration, that we issue new Texas Pollutant Discharge Elimination System permit number WQ00160560001 to Two Creeks Crossing Resort LLC as recommended by the executive director, and adopt the executive director's response to comments.
Thank you. I second the motion, but by way of passing to that point, I just want to observe how this matter in particular exemplifies the complexity of our agency's work and the business that it is. This is a request from the applicant with a member of the public who clearly is maintaining concerns and wanting to contest it further, and they fail to articulate the specific details of their concerns and complaints early enough in our process. And when we issue very complex technical permits, that's difficult for members of the public. So I just want to acknowledge that this is a hard one for me, but I'm in complete agreement and seconded.
Thank you, Commissioner. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries unanimously. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of an administrative order for the Bailey Metal Processors Incorporated proposed state Superfund site. The ED is the moving party and should present the matter, followed by any interested persons. Note that presently no one is signed in. And finally, OPIC. The Office of General Counsel recommends limiting the parties to 5 minutes for their presentations. And with that, we'll invite the ED to begin their presentation.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Cullen McMorrow with the Litigation Division. With me are Eric White and Sharon Barker of the Remediation Division. This is an administrative order to select remedial action for the Bailey Metal Processors, Inc. State Superfund site located northwest of the city of Brady in McCulloch County. As part of the state Superfund process, the TCEQ has investigated and performed a series of removal actions at the site pursuant to Chapter 361 of the Texas Health and Safety Code. The site housed a former scrap metal processing, copper and lead reclamation facility. At this time, groundwater and certain soils at the site are contaminated with antimony in excess of levels protected for groundwater ingestion. The soils are additionally contaminated with copper and lead in excess of applicable levels, which are protected for dermal contact, ingestion of soils or vegetables, and inhalation of volatiles and particulates. After notice and opportunity to comment, and in accordance with the Texas Risk Reduction Program rules, the executive director selected a remedy consisting of removal and offsite disposal of contaminated soil and establishing a plume management zone, which will prevent access to contaminated groundwater plume through institutional controls. The groundwater remedy also includes long-term data collection and analysis to monitor the plume and ensure its stability. Potentially responsible parties named in the order were given the opportunity to fund or conduct remedial activities at the site. No good faith offers were received. Therefore, there are no agreeing respondents. The executive director respectfully requests that the commission issue this administrative order pursuant to Chapter 361. We're available to answer any questions you may have, and we'd like to reserve the remainder of our time for rebuttal if necessary.
Thank you, Mr. McMorrow. I have none. Commissioner Lindley, no questions. Commissioner Janeka, saying none. No one has signed in to speak on this item. So, Mr. Arthur, what do you think?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCQ Public Interest Counsel. OPIC supports issuance of this order to list the site, determine PRPs, implement remedial action, and reimburse TCQ costs. Thank you.
Thank you, Mr. Arthur. I do too. I think, the site has a long history. I think we have now selected appropriate remedial actions, and we've satisfied all the legal predicates for listing on the state Superfund registry. So, colleagues, I'm ready to adopt the proposed order.
Thanks, I'm in agreement. All I'll say is, we really don't get to see our folks in Superfund much, so it's nice to see y'all. And, I just want to give y'all some kudos on how much work goes into this. It's arguably, these are the worst environmental issues, we have in this state, and y'all put so many hours, so much technical review into them, and they're just not talked about because y'all handle them and you get them done. And so I just want to say that I'm supportive of the order, and thank y'all for all the work that you do on this project and all the ones you do, because we don't get to, I don't know if get to is the way to say it. I enjoy seeing y'all, but I'm glad we don't have to have a lot of these come in front of us.
Thank you, Commissioner. As I'm passing the mic, I'll just ditto her remarks on our thanks to our great staff. Thank you.
I appreciate and want to echo those sentiments and add a little more of a wonky one. I think this is one of the program areas that we flagged as under state law we're really restricted to make sure we pick the lowest cost option, I believe. And I'm seeing some head nods. I hope that that's accurate. Thanks. I'm really sensitive to wanting to be fully conversant about what lowest cost of the state versus best value to the state is. And I think this program heightens the issues around that because it deals with permanent, lasting, long durable problems, and the slow activities of government to address those in a final solution. So I think the listed parties for this matter, the solutions that staff have identified, I'm really pleased with the level of detail and analysis that goes into it. We're open and try to communicate with the public, and I think it's a legally fraught area where stakeholders are always reluctant to engage. So I'm grateful for staff's tireless effort to really turn over all the rocks and evaluate all the options fully, particularly when we're constrained to make a choice based off of lowest cost. And in this instance, I'm pleased to see that those options, I think, arrive at also the best value for the state, but I just echo those kudos. And I'll end and make a motion that we adopt the ED's proposed administrative order concerning the Bailey Metal Processors Incorporated State Superfund site.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. That motion passes unanimously. Thank you. And Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, items 5 through 15. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 15. The total assessed administrative penalties are $206,943, with $9,615 deferred, $116,063 applied towards supplemental environmental projects, and $81,265 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions? Seeing none. Ms. Smith, is anybody signed in to speak?
No one signed in to speak, but on items 7 and 10, we have individuals who are available if the commission has any questions.
Thank you. Mr. Arthur, what does the Office of Public Interest Counsel say?
OPIC supports adoption of these enforcement orders as presented by ED staff.
I do too, colleagues. I think I'm ready to move forward with this enforcement docket.
Same, and I would move that we adopt items 5 through 15 as recommended by the executive director.
I heard a second from Commissioner Janeka. The motion's been made and seconded. All those in favor say aye. Aye. Motion carries unanimously. Ms. Smith, when you're ready, please call the next item.
Give everybody a chance to get up to the table. Item number 16 is the consideration of the publication of and hearing on amendment of 30 Texas Administrative Code Section 330.647, which are the approved regional and local solid waste management plans, and the executive director's staff is here to present this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I think this works. Can y'all hear me okay?
Might be mine. Go, let's keep trying.
The Executive Director respectfully requests the Commissioner's consideration of the proposed rulemaking amending 30 Texas Administrative Code, Section 330.647, to adopt the 24 approved regional solid waste management plans developed by the Texas Councils of Governments. The regional solid waste management plans contain goals for proper waste disposal, waste diversion from landfills, and waste minimization, as well as goals for increasing recycling and reducing illegal dumping in each region for the period of 2022 through 2042. The plans were developed by each Council of Governments using the most recent population, business, industry, and solid waste management data available from the state of Texas, universities, and financial and business entities. And they include regional growth estimates for population, commercial industrial sectors, and solid waste generation. I feel like holding it farther away makes it better.
Just work through it.
Okay.
Thanks.
I can speak pretty loud too, so y'all let me know. The regional solid waste management plans were made available for public review and comment in the regions. The plans were approved by the Councils of Governments, Solid Waste Advisory Committees, and Boards of Directors. TCQ staff have reviewed the plans to ensure consistency with the rule requirements, to identify concerns, evaluate data, and determine goals and plans of action for the regional management of solid waste. A hybrid in-person and virtual public hearing would be offered on this proposal in Austin on March 23rd. Please note that revised backup materials were submitted to provide a web link to the 24 Executive Director approved regional solid waste management plans. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Registry requirements. We are available to answer any questions you may have at this time.
Thank you. I have none. Colleagues, any questions? Seeing none, Ms. Smith, is anybody signed in to speak on this item?
No.
All right, Ms. Jamison, good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. I'm Jennifer Jamison on behalf of OPIC for the record. Our office has reviewed this rulemaking, and OPIC supports revision of 30 TAC Section 330.647 to adopt the 24 approved regional solid waste management plans developed by the councils of governments. Accordingly, OPIC supports publication of this rulemaking as proposed by the Executive Director. Thank you.
Thank you, Ms. Jamison. I agree. I appreciate the 24 councils of government submitting their plans to us. I think we're ready to put them out for public comment, which again will be the second time they're out for public comment. Commission, okay, I think we've got agreement from both of the other commissioners. I'm going to hand it off to one of you to make a motion.
It's just one of those weeks. I move that we approve the publication of and hearing on the proposed amendment of 30 Texas Administrative Code Section 330.647 as recommended by the Executive Director.
A second.
The motion has been made, seconded by Commissioner Lindley. All those in favor say aye. Aye. Motion carries unanimously. Ms. Smith, when you're ready, please call the next item.
Item number 17 is the consideration of the adoption of an amendment to 30 Texas Administrative Code, Chapter 210, Use of Reclaimed Water. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division, and with me is Todd Gallagher with the Environmental Law Division. The adopted rulemaking will clarify under Section 210.5A that an application to obtain an authorization under Chapter 210 may be submitted concurrently or anytime after submittal of an application for a permit to treat and dispose of wastewater for efficient processing, and as an incentive of applications and as an incentive to promote reuse within the state. The proposed rules were published in the October 7th, 2022 issue of the Texas Register. A public hearing was held on November 7th, 2022, and the public comment period closed on November 8th, 2022. The rule team did not receive any public comments during the public comment period. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 210. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you, and we're available for questions.
Thank you, Ms. Gibson. I have none. Colleagues, any questions? Seeing none, Ms. Smith, I think there may be someone signed in to speak.
That's correct. We have one person signed in to speak, Margot Denke Griffin.
Good morning, Ms. Griffin.
Good morning. Good morning, Commissioners. My name is Margot Denke Griffin, and I represent Friends of Hondo Canyon as well as Pristine Stream Teams, a small grassroots effort to help water in rural Texas Hill Country. My county's aim is to preserve the quality of our clear bottomed pristine streams and the quantity of our groundwater. We applaud the TCQ's efforts in requesting the rulemaking adoption, allowing TPDES or TLAB applicants to simultaneously apply for a 210 permit. Water is precious in Texas, and no water should be discarded as waste. While wastewater effluent is a significant contributor to the flow of the rivers in Texas, disposal of precious water by direct discharge is not always the best use of this water. The first item on today's agenda showed us the consequences of direct discharge of nutrient-rich wastewater into low phosphorus, pristine rivers, significant degradation with algal blooms, fish death, and stench. Yet this same wastewater that has the power to significantly degrade a pristine stream has the power to bring life to a hayfield, and life to a greenbelt. Beneficial use of wastewater is economically attractive. It is a reliable source of water. It saves fertilizer costs, and it saves groundwater resources for drinking. Thank you, staff and the commissioners, for bringing the consideration of beneficial reuse in its proper place, right at the time the applicant is faced with how they are going to treat and manage wastewater. Why hasn't there been any public comment supporting this? Because it's only one small sidestep towards what we really want to do. We're really asking the TCQ to take responsible and direct action to protect the few remaining low phosphorus pristine streams in Texas from receiving wastewater effluent. Our pristine streams are too valuable to be destroyed by wastewater discharge when the value of that water could be put to beneficial use. Thank you.
Thank you, Ms. Griffin. I think we'll hear next from the Office of Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta on behalf of OPIC. Our office has reviewed the proposed rulemaking. This rulemaking adoption will amend the requirements in 13 TAC section 210.5, and OPIC agrees that it would provide a consistent interpretation of the rules to obtain authorization for the use of reclaimed water. OPIC recognizes that it is clarifying the timing of the application to obtain an authorization under Chapter 210 rules for efficient processing and as an incentive to promote reuse. OPIC supports adoption. Thank you.
Thank you, Ms. Mehta. I do too. It's a clarifying rule. It is a very small step, but it is a very small step forward. So I'm ready to adopt it. Commissioner Lindley.
I'm in agreement as well. Do you have any comments? Okay, then I'm going to make a motion that we move to adopt the amendment to 30 Texas Administrative Code, Chapter 210, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye. Aye. The motion passes unanimously. Ms. Smith, when you're ready, please call the next item.
Item number 18 is our public comment session, and we do not have anyone signed in to speak at this time. We'll pause for a moment in case anybody here wants to indicate that they want to speak. Seeing no one, that would take us to the end of the items posted for the open session. Items 19 through 22 are for closed session, and the commission will meet in closed session today as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074, to take up and consider matters pursuant to items number 19 through 22. The commission will meet in room 211S of Building E at, should we say 10:30 or 10:30?
The time is 10:29 and we are in recess.